Bom dia a todos, boa tarde. É um prazer estar aqui em nome da Comissão de Direito e Relações Internacionais da OAB Santos. Agradeço ao nosso presidente, Dr. Richard Geraldo, agradeço à nossa moderadora, doutora Sueli Garcês, e ao nosso colega Daniel Toledo. E hoje é uma sessão muito especial, estou aqui hoje, terça-feira, às 9 horas da noite, em São Paulo, 8 horas da noite na Flórida e 10 horas da manhã na Austrália, para apresentar alguns convidados muito especiais, alguns maiores advogados australianos em atividade, um na Flórida e dois em Melbourne, onde eu tive a oportunidade de viver durante a adolescência. Então, agora vou falar inglês, eles vão fazer uma pequena introdução, vou traduzir essa introdução e depois passaremos para perguntas e respostas sobre o sistema australiano. Com certeza será uma sessão extremamente especial e enriquecedora. Obrigado a todos. Thank you to everyone. Well, Mr. Edward, I just would like you to introduce yourself on your general practice and the interesting of you being an Australian in Florida, and then I would ask Mr. Flores and Mr. San to do the same. So if you can go ahead, I would appreciate it.
Thank you, Olavo. It's good to see you again. Todaban, everyone, and bon dia, I believe it's morning, or no, evening. I'm sorry, evening. Bon noite in Brazil. But
it's going to be the afternoon. It's going to be in the afternoon.
Yeah, between Australia and Brazil. Just a little bit about my background. Third generation Australian. My grandparents on my father and mother's side left Lebanon in the 1890s, went to Brazil for about a year. And then on my father's side, they went to Australia in the 1890s, settled in Adelaide, South Australia. And on my mother's side, they went to Massachusetts, same time, 1890s. And then my grandparents, worked with other relatives in Adelaide, migrated there when there was a population of Australia was only a couple of million. They did very well in business. And then my father went to World War II for the Australians, fought in New Guinea. And then after a period of time, he started the first supermarket in Australia. And then we went to Melbourne. And then I studied law in Melbourne, Australia. Did 2 law degrees at Monash University, pursued a master's, taught corporate and business law at Monash. And then migrated to the US in the late 70s. I had to go back to law school, obtain an American law degree from the University of Florida Law School. And then I've been practicing US immigration law in Orlando, Florida for 37 years. So I've been an attorney for 39 years, 2 years in Australia practicing and teaching. And then back at the university as an adjunct professor of business immigration law, very much involved in the American Immigration Lawyers Association, do a lot of foreign investors coming in on the EB-5 program. But love it. We have a lot of clients from Brazil. Besides being the president of the Australian Chamber and the British Chamber, I'm also was vice president of the Brazilian American Chamber of Commerce for Central Florida. But in a nutshell, that's it. Love to talk about Australia and Brazilian relationships. I've said enough, but back to you, Olavo.
Well, thank you. Later, I would like to know which part of Lebanon your family was,
Because, and we have something in common, Olavo.
Yeah, so many Lebanese in Brazil as well. O Edward Beshara, um grande amigo desde a minha época morando na Flórida, é um caso interessante de um advogado australiano que atua na Flórida há mais de 30 anos. Ele, como muitos brasileiros, é descendente de libaneses, ele é a terceira geração estabelecida na Austrália, o avô dele era libanês. Eles se estabeleceram inicialmente em Adelaide, no sul da Austrália, e o pai dele depois estabeleceu um comércio, Mascate, e foi para Melbourne, onde ele foi criado, nasceu, foi criado e estudou na Universidade de Monash, e fez toda a educação dele na Austrália, até mudar para os Estados Unidos, quando ele estudou na Universidade da Flórida, e revalidou o diploma dele, e atualmente é um advogado praticante de direito imigratório para negócios, business immigration, né, na Flórida, e tem bastante clientes brasileiros, interesse no Brasil, fez parte da Câmara, foi presidente da Câmara de Comércio Brasil-Flórida, o capítulo central da Flórida, né, que ele mora em Orlando, né, e também é bastante ativo em diversas entidades de imigração na Flórida, nos Estados Unidos, e serve entre esse vínculo, esse liaison entre os Estados Unidos, o Brasil e a Flórida. Well, aí eu agradeceria. So thank you very much, Edward, and I would appreciate for Andrew to introduce himself, or Mr. San, Duy San, wherever first, please.
I'll go first. My name is Andrew Flower. I hold the qualifications of Bachelor of Law with first class honours from the University of Adelaide. I also hold a qualification of Master of Law from Monash University. In 1985, I moved to Melbourne, Victoria, where I did my articles of clerkship in Victoria. That is the training year for a lawyer. Since 1986, I've practiced consistently as a litigation lawyer, both principally in the fields of general commercial litigation and employment law. I've also done a smattering of immigration matters, including refugee matters, including injunction applications in the highest court of the country, in the High Court of Australia. I've practiced both as a solicitor and a barrister. To explain perhaps those quaint English terms, a barrister is what might be termed in the United States a trial attorney. I have practiced for 18 years on and off as an advocate, as solely an advocate, with experience in all jurisdictions, which I'll attempt to explain in a moment, at both a state and federal level, including lower state courts, the Supreme Courts of the various states, the Federal Court of Australia and the High Court of Australia. I continue to, from time to time, act as an advocate, but at the moment I'm employed as a solicitor with the legal firm Fernandez Kander Gherkins, or FCG Legal Proprietary Limited. That firm principally practices in the area of migration, but also my sideline is to act in relation to commercial litigation, either directly or as a consequence of the migration matters that the firm deals with.
It would be interesting later, and I think that's the first question on the general structure of the Australian legal system, to explain how the solicitor barrister works in Australia, whether you have to do trainings. Also, another thing that you mentioned is that you had to do a clerkship, whether you have to do a clerkship to be a practicing attorney in Australia, or whether you just have to go to law school and then sit for the bar. So those are some things that I think we can develop when we start our Q&A. So I'm just going to do a small translation on your general and very strong bio, and then we can go to Mr. San, and I appreciate for your time. Então, só falando que o doutor Andrew é advogado australiano, ele fez a educação dele na Universidade de Adelaide, depois ele mudou para Melbourne, onde ele continuou a educação dele na Universidade de Monash. Ele é um advogado especialista em contencioso, principalmente contencioso comercial, essa área de especialidade dele. E ele ele mudou para Melbourne também para fazer o estágio dele, que é o clerkship, que é o estágio obrigatório. A gente pode discutir sobre isso, como é que funciona o sistema australiano. E ele tem bastante experiência nessa área contenciosa, litigiosa. Ele já advogou perante tribunais superiores australianos e advogou tanto como barrister como solicitor. Barrister, solicitor, baseado no sistema britânico. Normalmente, barrister é um advogado mais de tribunais inferiores, um advogado mais litigioso, né? E o solicitor normalmente advoga perante tribunais superiores da superiores no Reino Unido, e high court, né, altas cortes, tribunais, e a gente vai ver como é que isso se aplica na Austrália, justamente também por todo esse vínculo com o Reino Unido. Mr. Duy San, if you could tell a little bit about your background, I would appreciate it. We would appreciate it from the public.
Yes, so I obtained my Bachelor of Law degree at Victoria University in Victoria. My parents came here as refugees back in 1970s. I was actually born here. So I'm an Australian Vietnamese, I guess, immigrant. So I'm a lawyer working for FCG Legal in Australia. I mainly work in immigration law. So our practice, we assist visa applicants from the primary applications and also to complex matters such as visa cancellations, and also have assisted clients at the Federal Circuit Court and Federal Court as well.
And so I'm sorry to express, your parents were both people, as it was called, right?
Not both people, but refugees. They came through, the airport. Yeah.
Which university you studied at?
Victoria University.
Victoria University. Okay. So I'm just going to translate a little bit. Então, o Duy San, ele é filho de imigrantes, filho de refugiados vietnamitas. Ele nasceu na Austrália, mas os pais dele vieram como refugiados para a Austrália, foram aceitos como residentes na Austrália. Ele estudou Direito na Universidade de Victoria e ele trabalha no mesmo escritório que o Dr. Andrew. Essa área de especialidade dele é principalmente Direito Imigratório e o escritório deles fazem bastante essa parte de Direito Imigratório Empresarial e também outros casos mais focados em questões humanitárias, entre outros. Vou até perguntar isso para confirmar. Your firm does humanitarian immigration law as well, right? Besides commercial immigration.
That's correct.
Right? Okay.
That's correct.
Então, sim, então fazem. Então, partindo agora para a nossa pergunta, que envolve, inclusive, essa questão de refugiados na Austrália, a primeira pergunta que eu vou fazer é sobre a estrutura geral do sistema jurídico australiano, recordando que a Austrália é uma república, é uma monarquia federativa, né? Então, tem um primeiro-ministro, que é um primeiro-ministro eleito, pelo parlamento eleito, que é o primeiro-ministro Scott Morrison, mais a chefe de Estado é ainda a Rainha da Inglaterra, e justamente como é que isso funciona numa monarquia constitucional federativa. Federativa por quê? Porque a Austrália tem estados e territórios federais, como o Brasil, como os Estados Unidos, por exemplo. Okay? Apesar de atualmente o Brasil não ter mais territórios federais desde 88, teoricamente no sistema federal há essa possibilidade de territórios federais. Então, vou perguntar para ele sobre a estrutura geral do sistema australiano. So, the first question, like I was telling the audience, is since Australia is a federal constitutional monarchy and it still has some links with the UK, and that's the first thing that any person would ask about Australia, is that since the Queen is still the head of state, how does the general Australian legal system works? How it's divided? How here in Brazil, for instance, we have federal courts and state courts because we are also a federal system. How does it apply in Australia? And do you have, as you have in the British Caribbean, I studied with a very well-known Caribbean law expert in Miami. Do you still have formal links with the British legal system? Does cases in Australia still go to the private counsel in London, or how does that work? Let me just translate that last part for the audience, and then you can start answering, okay? A pergunta que eu estou fazendo é, visto que o sistema jurídico australiano, a Austrália é um sistema federativo e ainda tem vínculos com o Reino Unido, pelo menos formais, como é que a estrutura do sistema judiciário australiano é dividida em tribunais federais, estaduais, como o Brasil, como os Estados Unidos, e se por ter esses vínculos com o Reino Unido, se ao exemplo do sistema caribenho, estudei em Miami como professor de direito caribenho, ainda existe vínculos com o Reino Unido, com tribunais britânicos. Sistema caribenho, Jamaica, Bahamas, entre outros países que faziam parte do Commonwealth, fazem parte do Commonwealth, a Corte de Apelação Final, que seria o STF deles, é o próprio tribunal em Londres, Privy Council. E eu queria saber se a Austrália ainda tem esse vínculo ou se esse vínculo não existe mais. Se é um sistema judicial extremamente, completamente independente. So that's the first question, and feel free to answer. Thank you.
Thank you, Olavo. Now, that question is what we barristers would call a rolled-up question, and it would be objectionable in a court of law. There's about 14 different questions in that question. We not being in a court of law, I'll attempt to answer your question step by step. Australia is both a federal system and a constitutional monarchy. Can I deal with each one in turn, although they're inextricably connected in lots of significant ways? Dealing with federalism first. Prior to 1901, Australia consisted of 6 British colonies and 1 territory administered by the colony of South Australia. In the 1890s, the colonies got together because of the inefficiency of the system and decided to hold a series of conventions with a view to forming a federal government and a single Australian government. To that end, a British piece of legislation called the Constitution of Australia Act was passed by the British Parliament, and that became the Federal Constitution of Australia. That was adopted by referendums held in each of the states, and the Commonwealth of Australia, the national government, came into operation on the 1st of January 1901. The system in that sense is similar to the Brazilian system, namely that there is a federal government and 6 state governments. The power of the federal government is regulated by what has become the Constitution. Any area of power not dealt with by the Constitution is part of the residual constitutional authority of the various state governments. For example, there is no express federal power in relation to health or healthcare, so all the states run all the hospitals. For example, there is no express federal power in relation to education, so the states run all the schools and universities.
Andrew, just a small question that's of curiosity, and regarding the links with the UK, we can go do that in a second part. But let me ask you something. This constitution that was adopted in Australia is from which year, and is it still in force? Is it still the same constitution?
Yes, it is. It was introduced in 1901,
okay,
and is still in force, and is still the constitution. It's still the written constitution of this country. The federal government has a written constitution, and it is by reference to the interpretation of that document that the limits of power on the federal parliament and the federal courts and executive is determined.
Ok. Então, só fazendo uma pequena tradução aqui, a Austrália eram colônias britânicas, como muitas pessoas podem ter conhecimento. A Austrália começou como uma colônia penal. That's very, people talk about Australia, that was a penal colony. That's why I'm saying everyone mentioned
Yes, yes, initially it was.
Yes. Então, a Austrália começou, como muitos sabem, como uma colônia penal, e onde iam os detentos, né, do Reino Unido, e foi, durante muito tempo, uma colônia britânica, até que em 1901, as 6 colônias britânicas, que estavam na Austrália, mas território federal, se uniram para estabelecer um governo unitário, um governo independente, e com isso, com autorização do Reino Unido, então houve uma autorização do Reino Unido, foi feita uma Constituição, que inclusive, pelo que eu entendi, foi passada pelo próprio Parlamento Britânico, e essa Constituição foi adotada em 1901, e com essa Constituição, já em janeiro de 1901, se estabeleceu a Austrália como um sistema federativo. E a Austrália, sendo um sistema federativo, tem uma Constituição escrita que ainda está em vigor, essa Constituição administra esses 6 estados mais território federal, que existe na Austrália, alguns estados, territórios federais que existem na Austrália, e a Constituição estabelece, como a Constituição brasileira, como a Constituição norte-americana, mas acho que mais forte que a Constituição brasileira, poderes residuais aos estados. O que não está previsto pelo governo federal é de competência dos estados. E aí nisso se inclui o direito à saúde, que é administrado pelos estados, que não está expressamente previsto na Constituição Federal, e o direito à educação, que também não está previsto expressamente na Constituição Federal Australiana, que também é administrado pelos estados. So please, Andrew, sorry to interrupt, if you want to continue.
Yes, by Section 61 of the Commonwealth Constitution, the executive power of the federal parliament is vested in the Crown of the United Kingdom, that is in the Queen. That executive power is exercised by her representative in Australia, the Governor-General. Likewise, each of the state parliaments, and there being 6 of them, have as their executive head the Queen, and her power in the state governments is exercised by state governors. So we have the curious situation in Australia of having 7 crowns, as it were. We have the crown in right of the Commonwealth, that is the Queen exercising executive power for the Commonwealth, and the crown in right of each of the states, that is the Queen exercising power in relation to each of the state parliaments. It's a bit of a strange concept, a bit like the Holy Trinity, only there's 7 of them rather than 3. It's supposed to be an indivisible crown, but there are apparently 7 of them. Now, getting back to one of your questions, what impact does that have in relation to the connection of the British system to exercise power in relation to the Australian Commonwealth Parliament and the Australian states? The answer to that is, from a practical and political perspective, virtually none. From a political standpoint, Australia is a sovereign country. It acts on the world stage as such, and the influence of the British Crown from a practical perspective in the Australian legal and political system is 0, although theoretically, if the Queen decided to stick her nose into Australia's affairs, she's got the power to do so.
Sorry, could you repeat that last part? If the Queen decides what?
If the Queen decided to exercise executive power in relation to any of the Australian states or the federal government, she, in theory, has the power to do so, but in terms of constitutional convention, has never done so.
So it's like more or less like the UK, and then when the Queen grants royal prerogatives to the Prime Minister to govern, and also in theory in the UK she can withdraw those royal prerogatives. So it's more or less the same situation.
The Governor-General and the governors of each state have prerogative powers which they can exercise, and those powers have been exercised to dismiss state premiers and a Commonwealth Prime Minister twice. In 1939, I think it was, the state governor of New South Wales, Sir Philip Game, dismissed the then Labor state premier Jack Lang, and of course, famously in 1975, Sir John Kerr dismissed Prime Minister Gough Whitlam.
In
both of those incidents, it was the exercise of the royal prerogative, the prerogative powers of the Crown that were brought in aid of those actions. So those powers still do exist in the Australian legal system and political system.
Let me ask you something. I would like us to spend on the judicial system in Australia to understand what are the links with the UK. But what you're saying, those situations were the Queen that dismissed or the King that dismissed those prime ministers, or
no. Sorry, I didn't mean to suggest that. The Queen's representatives in each state. That is, the Governor-General or the governors exercise that power.
So they can interfere on state governors. That's the situation. They can.
The state governor has a prerogative power to dismiss a state premier, and the Governor-General has a prerogative power to dismiss the Prime Minister. Each state has its own premier.
I understand. So the Governor-General is a different political entity than the Prime Minister. He still exists, and he's not elected. He's a representative of the Australian Crown, of the British Crown in Australia. That's it?
Yes, that's correct.
That's a lifelong position?
No, his or her appointment is renewed from time to time. Okay. I'm not sure what the term is. I think it's 5 years, but I'm not completely sure on that.
Okay. Olavo, just a point of clarification. A lot of Brazilians are very familiar with Florida, right? Now, Florida, the head of the state government in Florida is called a governor. Right?
Okay. Yeah.
And as Andrew was just explaining, the head of the state government is called a premier. Not to confuse that with the governor that represents the Queen, represents the monarchy. In each state, it's the governor.
Yeah,
you understand that there's a difference between governor and premier. Okay.
Yes, understood that. So what's the name of the title again? It's General Governor, right? The guy who
the Commonwealth government has a Governor-General.
Governor-General, and what's the name?
That's the person that exercises the Queen's executive power in Australia.
Does he has strong roles, or is more of traditional?
Mostly it's ceremonial. It will only mostly it's ceremonial, and there's an executive council that proclaims legislation. But other than that, any drastic powers or prerogative powers are very, very rarely exercised. They're there, but they're never exercised.
What's the name?
There's a constitutional convention that the Governor-General must act upon the advice of his Prime Minister, and that is pretty much always adhered to.
Okay, let's translate that. That's interesting. What's the name of the Governor-General?
At the moment, good question. I'm not sure. They keep appointing these military fellows.
So it's not that important.
That's a pretty bad miss on my part. Hang on.
Oh, you can explain that. Só falar uma coisa que é interessante.
David Hurley is the current Governor-General. He's a retired military man.
And he's British or Australian?
No, he's Australian. We haven't had a British Governor-General for quite some time.
Oh, that's cool. So it can be an Australian person.
Yes, okay. Yes.
Okay, very interesting. Só explicando que como a Constituição, inclusive, foi feita com a participação do Reino Unido, na Austrália, o representante da rainha na Austrália é uma figura chamada governador-geral. Né? Existia no passado governador-geral das colônias, né, em várias partes do Commonwealth britânico, e o governador-geral, que é o representante da rainha na Austrália. Esse governador-geral não precisa necessariamente ser britânico, ele pode ser australiano também. Já faz bastante tempo, muitas décadas, que há um governador-geral que tenha sido britânico. Então, é australiano esse governador-geral, é uma figura bastante... como posso dizer, tradicional, mas sem grandes atribuições, né? E quem governa no dia a dia é o primeiro-ministro, né? Como a Inglaterra tem primeiro-ministro, como o Canadá tem primeiro-ministro, como Israel tem primeiro-ministro, a Austrália também tem um primeiro-ministro, que é escolhido pelo parlamento e tudo mais. Mas o governador-geral da Austrália, teoricamente, ele ainda pode... destituir, a pedido da rainha, primeiros ministros, tanto do governo federal, né, o primeiro-ministro australiano, quanto os governadores estaduais. Né? Em todos os estados, ainda a figura do chefe de Estado é a rainha. Então, eu estava até brincando que existem 7 chefes de Estado, né? Porque tem a rainha como chefe de Estado do governo federal, com sua representante na Austrália, que é o governador-geral, Governor General, o chefe de governo, que é o primeiro-ministro, e todos os estados têm governadores, todos os 6 estados da Austrália têm governadores, né? Com parlamentos e tudo mais, mas o chefe de Estado, nem todos esses estados, é a própria rainha da Inglaterra. Então, ainda existe esse vínculo. A Austrália é independente, faz seu papel, atua, tem suas forças militares, é uma nação soberana, mas, teoricamente, o governador-geral, a mando da rainha, poderia... que é uma figura cerimonial, essa palavra que eu estava pensando, cerimonial. O governador-geral, teoricamente, pode atuar a mando da rainha para destituir governantes australianos eleitos pelo Parlamento Federal ou Parlamento Estadual. Okay? So let's continue. And if you guys want to talk a little bit about the judiciary, it would be interesting to know on how those British ties still act on the judiciary, and also whether you have and I teach in a course on American legal system, right? So whether you still have a pure common law system as in the UK, and what are the British ties with this judicial system, and also if it's divided into a federal and state courts as in the US and Brazil. And finally, I think it would be interesting to know the difference between barrister and solicitor, how this applies in Australia.
Yeah, the Australian legal system is a common law-based system. That is, initially, when it was set up, it was based upon British law. British common law still forms part of the law of Australia. However, over the years, Australian courts have developed their own jurisprudence based upon their own legal decisions, but British judgments and British legal decisions still form a significant part of the common law of Australia. For example, the law of negligence in Australia derives from a 1932 British House of Lords case, which is still fundamental law of this country. The judicial system is a 2-tiered system. Under Chapter 3 of the Federal Constitution, the High Court is established and the Parliament has power to set up federal courts. It has set up the Federal Court of Australia, the Family Court of Australia, and a court underneath that called the Federal Circuit Court. Those courts can only deal with matters that the federal parliament can deal with. For example, the federal court will deal with matters such as taxation law, which has become a federal exclusivity. Importantly, migration law, and other areas of federal law such as bankruptcy and consumer protection. Every other area of law that is not dealt with by the Constitution is province of the state courts. And there, in each state, there is a hierarchy of courts. In Victoria, the lowest level of court is called the Magistrates Court. We then have an intermediate court called the County Court. We then have the highest state court is the Supreme Court of Victoria, which has 2 divisions, the Ordinary Division and a Court of Appeal. So going up the system, ultimately, sorry, can I just pause there for the moment? The High Court is in effect the Supreme Court of Australia. The United States has its Supreme Court. The equivalent in Australia is the High Court of Australia. And that serves as the ultimate appellate court for both the states and the federal system. So the pyramid comes to a point at the High Court, which will decide both federal matters and state matters. Now, prior to 19 1976, there existed the ability to appeal from the High Court to the Privy Council in the UK.
Okay.
That right of appeal has now been abolished by legislation. So the highest you can go in Australia now is the High Court of Australia.
I'm sorry, this ended in 1976, this link with the Privy Council then.
Yes, it did.
And just to understand something, you said that the federal system, the state system is a three-tier system in most states or in all states?
Pretty much in all states. There'll be a lower court, an intermediate court, and then the Supreme Court. And most Supreme Courts have an appeal division as well.
And in the federal system, is only two tiers. You go from you don't have intermediate appellate court.
No, there's just what's called the Federal Circuit Court, and then there's the Federal Court, and that has an appellate bench as well.
Oh, it has an appellate division on it.
Yes. So in theory, if you've got say a migration case, it's decided in the Federal Circuit Court, that can be appealed to either the Federal Court or the Federal Court full bench, and then from there it goes to the High Court. Okay, and what established what goes from state courts to the High Court? Is the Australian Constitution, or is it a matter of constitutional interpretation? And also, what established what's federal matter and state matter is those residual powers of the states that you mentioned. The Australian federal Constitution established what goes into federal courts. It lists what goes into federal courts, and what's not listed then goes into state courts. That's how it works. That is correct. That is an accurate analysis. The whole basis of federal jurisdiction and federal judicial power is determined by the Constitution. So if it's not a federal matter, it will be determined by a state court.
Okay. So, só apenas fazer uma tradução rápida que é interessante, é que a Austrália tem um sistema federativo, então tem tribunais estaduais e tribunais federais, e os tribunais estaduais, os poderes legislativos, executivos estaduais trabalham bastante com a questão de poderes residuais, ou seja, a Austrália, a Constituição estabelece um sistema federal de tribunais. Você tem dois tribunais, né, tribunais federais, tribunais de circuito federais, e o sistema e existe um tribunal federal, que é uma corte de última instância federal, que é a corte mais alta australiana, High Court, né, corte mais elevada. Essa é a última corte, no último tribunal na Austrália, é o tribunal final, e isso se aplica também para tribunais estaduais. Os tribunais estaduais podem funcionar em dois níveis de apelação, primeira instância e segunda instância, ou, como nos Estados Unidos, três níveis de apelação, primeira, segunda e uma corte suprema daquele estado. Nós estamos falando apenas com profissionais de Melbourne, na Austrália. Eu mesmo morei em Melbourne, na Austrália. E no caso de Melbourne, no estado de Victoria, você tem três níveis, com a Suprema Corte da Austrália, a Suprema Corte de Victoria como o último tribunal de apelação. Porém, em alguns casos, e aí é isso que eu quero elaborar agora, pode haver apelação para High Court, para a corte mais elevada australiana, que é essa corte federal, de casos estaduais. Okay? Como também existe essa possibilidade nos Estados Unidos de casos estaduais irem para a Suprema Corte dos Estados Unidos. A grande questão aqui, e a minha curiosidade pessoal, é que não existe mais um vínculo direto com o Reino Unido. Até 1976 havia a possibilidade de casos que fossem para essa última Corte Federal Australiana, High Court, serem recorridos por Private Council, que é um tribunal no Reino Unido. Alguns países do Caribe britânico ainda mantêm esse vínculo, como mencionei. Mas a Austrália, a partir de 1976, aboliu isso. Então, não existe mais a possibilidade de casos na Austrália irem para o Private Council no Reino Unido, em Londres, isso acabou, então a High Court é o último tribunal, o Tribunal Supremo Australiano, tanto para casos federais quanto para casos estaduais. E, por fim, é interessante mencionar que a Austrália é um sistema puramente de common law, do direito costumeiro, onde os casos ajudam a moldar o direito estatutário, o direito escrito. Isso é bastante importante, e o importante também, isso como os Estados Unidos, como o Reino Unido, como outros vários países, é um sistema de direito costumeiro, common law, mas o mais importante é que ainda existe uma influência bastante forte do direito britânico no sistema australiano. Hoje em dia menos, mas no passado diversos precedentes do sistema britânico foram aplicados dentro do tribunal australiano, quando eles estavam construindo precedentes. Então, casos como ele mencionou, como de negligência, entre outras questões, foram trazidos por decisões britânicas que foram interpretadas perante a realidade australiana. Okay, what I was going to ask you, we were talking about Australian courts, and just to understand, so you said that what established what goes into federal courts, and even if our state cases, is the federal constitution, right? So
that's right.
Yeah,
that's what.
But Olavo, Andrew, the High Court, at its discretion, can still hear appeals from lower courts. Is that right?
Yes, it can. The High Court has a similar system to what the United States Supreme Court now implements. Namely, it's got a system of seeking special leave to appeal. It will only take such cases as it regards as significant cases from state courts and the federal court. So if it's not going to change the law, or if there's not conflicting decisions, or it's not an important issue, the High Court will not deal with it. And I would say that 80% of all special leave applications to the High Court are rejected. It only takes a very limited range of cases from the state and federal courts. It has exclusive jurisdiction in relation to the interpretation of the Constitution. So all constitutional cases are taken on by the High Court, but otherwise it's got a system of filtering such that it only takes what it wants to take on.
Sure.
Okay, let's translate that, and then we can move to the second and final part, which is on immigration in Australia. In the US, this is called writ of certiorari, what you mentioned. In Brazil, we call general repercussion. Also, we have that nowadays in Brazil, repercussão geral. So, special leave, right? So, na Austrália, como nos Estados Unidos, que tem o writ of certiorari, um pedido de writ of certiorari, ou no Brasil, atualmente, com a reforma trazida pelo Emenda Constitucional de 2004, que trouxe a ideia da repercussão geral, a Corte Suprema Australiana, que é a chamada High Court, ela seleciona os casos que vai analisar. E, para isso, o peticionante, quem está peticionando para ter caso tanto vindo do sistema estadual quanto do sistema federal perante a High Court, entra com pedido de special leave, né? E esse pedido de special leave pode ser aceito ou não pela High Court para análise. Eles só vão analisar casos que tragam, geralmente, uma interpretação, alguma questão relevante para o direito australiano. E aí foi me trazido que cerca de 80% dos casos que são levados perante a High Court são recusados, por não atenderem os critérios de interesse geral para a sociedade australiana, de trazer um precedente importante para o direito australiano, etc. Então, agora, a gente, por uma questão de tempo, a gente vai mudar para a segunda parte, que provavelmente o Dr. Duy San vai trabalhar, que é a questão da imigração australiana e a questão também de como a Austrália vem encarando o Covid e como é que isso afeta a sua política migratória de refugiados e tudo mais. Então, vou perguntar e daqui a pouco passo para a tradução. I would like us to spend with Mr. Duy San, and I thank you, Andrew, for your explanation. And I would like to know a little bit on the Australian immigration system regarding what if Australia has a similar system to Canada or the United States how does it operate if you still adopted a point system, because Australia is such an empty country and still needs its skilled labor, and also how this has changed with the COVID crisis. I think it would be important to establish that. We have seen in the past news on Australia sending refugees to islands, offshore islands, detention centers in offshore islands. And I would like to know how this Australian policy works as a whole, and if you could give us a general overview on that. Thank you.
Yeah, sure thing. So first I'll speak about skilled workers and their visa options. So there are many visa options for skilled workers, but they can basically boil down to two structures. For example, the point system, very similar to Canada, where skilled workers obtain a number of points on the basis of their age, their work experience, and their qualifications. They lodge an expression of interest with the Australian Department of Home Affairs, and depending on the amount of points they can obtain, they get invited to apply for a visa. However, over the many years, the point system for skilled workers have become very competitive. For example, previously it was you obtain a minimum of 70 points, you get an invitation from the department. However, we've seen invitations only being invited to people who have obtained only up to 90 points. So it's been quite very competitive, and they've reduced intake to quarterly intake, so every 3 months. And I've had a look at the last invitation round. They've only invited about 500 visa applicants to apply for.
Last year?
This year, only 500.
But this is on a COVID year. In years that you don't have COVID, what's the average, more or less?
From October last year, well, it's a bit hard to say, but it's definitely been reduced. Even in the COVID, even without the COVID climate, it's about 1,000, and they've reduced it to quarterly. It used to be monthly, but it's been reduced quarterly.
Okay. Before I translate, just you said that they're requiring 90 points. This is out of how many points?
It's a maximum of 120, but the minimum you need to obtain to apply for an expression of interest is only 65.
Okay, and this is
even before COVID. Let's say in 2016, they were inviting applicants with about 70 to 75 points. But from 2019, we were seeing only invitation being to people who have obtained about 90 points.
And this is on the point system. What's the name of the program?
It's a skilled independent visa. The subclass 189 is the main point system.
Skilled independent visa. And
yes.
Do you have any other types of visas that you like to discuss, professional visas before?
Yes, for skilled workers, the other alternative is the subclass 482 temporary skill shortage visa. Now, this visa requires you to have an employer lined up and an employer sponsoring you for a particular occupation. And with all visas in Australia, depending on the subclass, they all have their own specific skill occupation list. So for example, if you want to apply for the skilled independent visa, your occupation needs to be on the subclass 189 skilled independent visa list. If it's not on the list, then you cannot apply for that subclass.
And you have to do that from outside Australia? Do you have an adjustment of visas, or all the applications you have to be done outside Australia before?
They can be offshore. They can be offshore or onshore, yes. But with the skilled independent visa, you need an invitation from the department before you can lodge an application.
But can you join Australia, for instance, do you have visa adjustments in Australia? Can you join as a tourist or not a tourist, but maybe as a student, and you decide to stay in Australia and you adapt your visa because you get a job offer in Australia? This can happen as well.
Yes, as long as you have for example, a student visa or visitor visa to come in Australia, and for whatever reason you find an employer willing to sponsor you for, let's say, the temporary skill shortage visa, yes, you can apply onshore. And it's much preferable that you apply onshore because you get what is considered a bridging visa whilst you await a decision on the application.
Just to follow up on what you're saying, when you say a decision is made, and Olavo would be interested in this, it's a discretionary decision making by the Australian government, correct? The Australian Immigration Service. So it's discretionary. So when you're waiting for a decision, it's not like in a civil system, like in Europe, where if you supply, 6 out of 10 documents or 10 documents that are asked for, you get an automatic decision. But there's discretion in the decision making by the Australian immigration system?
Not necessarily so. For each particular visa, there are visa requirements. There's documents you need to satisfy, there's documents you need to provide. For the temporary skills shortage visa, I guess one of the discretionary factors are the genuine need requirement. The department needs to assess whether there's actually a genuine need for the employer to sponsor the visa applicant. And that's where they can consider, your organization structure, your financial, capacity to employ the employee. And I've also got here, whether the position actually fits in the business. I mean, if you've got a small restaurant and you're
more likely than not, the decisions are affirmative. What's the percentage rate of requests for further evidence or denials?
I don't have the exact number in front of me, but the request for further information, most of the time they are requested. Refusals really depend on whether the migration agent or the migration lawyer has provided everything at the start of the application. The way we do things at FCG Legal is that we prepare the application where it's decision ready, where the department is less likely to request for further information because all the documents and all the required visa requirements have been satisfied, and we prepare a submission that addresses each and every visa requirement.
Yeah. Okay, I think that I would like to just explain this a little bit to the audience, but after I think you can have a general look at other visas like investment visa, family reunification, and the Australian general intake on refugees. And I think that we can wrap it up because, like I said, we have about 1 hour. So I think that would be suitable. Mas só falar que o doutor Duy, ele estava explicando que a Austrália tem, como o Canadá, um sistema de pontos, ou seja, você pode migrar para a Austrália se você atingir aquele determinado número de pontos, e são 120 pontos a serem alcançados no máximo, e normalmente a Austrália costumava a convidar pessoas a que alcançassem 70 pontos, em média, né? Então, leva em consideração a sua idade, sua ocupação, se você fala inglês, tudo isso vai somando. Mas que a Austrália está bem mais rigorosa e agora eles só estão aceitando pessoas com 90 pontos ou mais, né? Isso daí já vem antes da pandemia, né? Já vem antes da pandemia, e que a Austrália, nesse sistema de pontos, costumava aceitar cerca de 1.000 profissionais por ano e vem aceitando cerca de 500, mais ou menos. E além do sistema de pontos, que é algo que a Austrália divide com o Canadá, a imigração, né, sendo países com necessidade de trabalhadores profissionais e tudo mais, existe o sistema de patrocínio por uma empresa, de você ser contratado por uma empresa e a empresa te trazer para trabalhar na Austrália. A minha dúvida é se ambos esses sistemas precisavam ser feitos de fora da Austrália. Quanto ao sistema de pontos, quem tiver interesse em migrar para a Austrália precisa realmente entrar com o procedimento fora do país, esperar uma carta convite para ir para a Austrália, depois do procedimento ter sido terminado, né, completado. Mas em relação à questão por emprego, você pode estar com visto temporário na Austrália e eventualmente ter interesse no empregador, e aí você entra com pedido para que você possa continuar na Austrália enquanto esse processo esteja acontecendo. Então, pode acontecer de ser feito de dentro da Austrália, enquanto você está gerando a confirmação daquele emprego. E agora a gente vai falar um pouquinho sobre essa questão da reunificação familiar, da questão dos refugiados, da questão talvez de visto de investimento, e completar por hoje. Qualquer dúvida que vocês tenham, depois disponibilizar o e-mail dos profissionais aqui, e estão super dispostos a trazer maiores esclarecimentos. Obrigado. So, there any other relevant general ideas on the immigration system, on other type of visas, family reunification? Do you have an investment visa that you can invest a certain amount of money in Australia? Do you have to generate jobs as you have to do in the United States? How does that work in general?
Yeah. So I will start off with the visitor visas. So we definitely have about 3 subclasses for visitor visas. Usually it's the subclass 600 that people apply for, and you just have to show genuine intention to travel to Australia as a tourist or for business purposes. In the visitor visa stream, there is also a stream where a family member can sponsor you to come to Australia to visit. In that particular stream, however, there is a visa condition that states that you will leave once your visa expires. So there's no opportunity to apply for a further visa if you were sponsored to come here to visit. Okay. There are certain visas for different countries as well. For example, the United States, Malaysia, and Taiwan. It's called the Electronic Travel Authority. That is a very straightforward visa application. During the COVID, pandemic, the department's actually trialing this mobile application where you just scan your passport and pay the $20 fee if you've got the passport from the requisite country, and the visa gets granted automatically. So that's the fast and simple way to get a visitor visa. However, that's only for limited countries such as United States and Malaysia at the moment.
Duy, is that called the ESTA? Is that ESTA what you're referring to?
It's the ETA. So I guess it's equivalent to the American ESTA visa.
ETA,
and it's just straightforward.
And you have to have a treaty between the two countries, an agreement between the two countries, that agreement with the country at stake, and then there can be.
It's not necessarily an agreement. I guess it's more of the department has assessed the risk of each country, and they've put a particular list of countries where there's a low risk of applicants or visa holders overstaying Australia.
Okay.
Yeah. I'll now talk about the family visas. So with the family visas, usually the main pathways for families are for partners, spousal or de facto partners, or parents. There's also parent visas and also partner visas. But in particular for siblings, siblings would only be able to apply for a visa to come and live in Australia if they're the last remaining relative in the other country. For example, if for me, my parents, if I had my father over back in Vietnam and he had no other family members except for me and my family in Australia, then he could apply for the remaining relative visa. However, with that particular visa, there is a processing time for about 30 years. So it's quite ridiculous. They've tried to remove it in the past, but the courts have deemed it unlawful. So what it seems that they have done is just put a processing time that's absolutely ridiculous.
But what about children? Does it have to be?
Children, yes, definitely.
But does it have to be under 21 as in the US, or it doesn't have an age requirement? And the
child visa, particularly the child visa, has to be under 18, unless you can prove that the child is still dependent on you. For example, if they're still going to school, and if you provide evidence that you're sending them money as well. There is also a partner visa where the child can be included as a dependent on the visa as well. But that restricts it till the age of 23.
And what about domestic partners? You accept that as besides marriage? You accept civil unions, and do you accept
Yeah.
also gay
Same-sex marriage,
same-sex?
and same-sex de facto relationship as well. So in a de facto relationship, you just basically, in addition to proving that you're in a genuine relationship, you need to prove that you've been living together for at least the last 12 months.
But also same-sex marriage. Yeah.
Is that for a non-immigrant process, the de facto, or do you have to have an actual marriage record for permanent residency?
No, you don't have to. Australia recognises de facto relationships and also spousal relationships, so you don't have to have a registered marriage certificate to apply for that visa.
Okay. That would be very important for Brazilians, Olavo. That they don't have to have an official marriage record, to get into Australia, because, you can be married in Brazil without the actual marriage record or certificate. You can still have this de facto relationship. So what Duy's saying is that that's good enough, right, to get into Australia.
Yes. Yes. Sorry, go on.
No, yeah, understood. I think that's important. Some countries don't accept that de facto marriage. You have to have actually show a marriage certificate and all of that. So I think that the last thing I wanted to ask is how Australia regarding refugees and how is the general policy, and how the COVID is affecting immigration to Australia, right? In terms of,
Yes.
you hear, for instance, of Australian citizens being forbidden to go back to Australia. And I would like to know a little bit about that. But let me just tell a little bit on family reunification, and then we go back to that, and then we close. I think that it would be a good idea to say how you can practice law in Australia as a foreign citizen, but I don't think we have time for that. So this is going to be for a next section. I don't think we have time to spend on that. But só falar uma questão, porque nós estamos entre advogados imigratórios, então isso acaba sendo um tema de interesse de todo mundo, né? Mas sobre reunificação familiar, a Austrália existe reunificação familiar para parentes, filhos, esposos, né, companheiros e também para irmãos, né? Só que para irmãos precisa demonstrar que você é o único irmão da família, né? Que existe um vínculo fortíssimo, e os processos podem demorar mais de 30 anos, né? Então por isso que a gente deu até risada, né? Mas em relação a casamento, a Austrália reconhece também a união civil, né? A questão da união estável, e também reconhece uniões homossexuais, homoafetivas, para fins de reunificação familiar. Em relação a crianças, em geral, precisa ter abaixo de 18 anos de idade para reunificação familiar, e se for acima de 18 anos de idade, precisa demonstrar que há uma questão econômica, de dependência econômica, entre outros fatores. For 23 years is for what? I'm sorry, can you say again? For
the dependent child for a partner visa. So you're only considered a dependent of your parents up until the age of 23 years old. So even after the age of 24, even if you're dependent, it doesn't, under the definition of Migration Act, you're not considered a dependent on your family, on your parents.
Regardless of whether you're economic dependent or not, 23 is the limit for every case. Is that it?
Yes, for the parent, for the partner visa. Yes, that's correct. And because with the Australian visa system, you can be a primary applicant and then include your children as well as part of the application. However, once they turn 23, they cannot no longer be included as part of the application.
Entendi. Então, assim, uma vez que você está se inscrevendo para o sistema australiano, você tem filhos, né? Você pode pôr como dependentes para que eles possam também imigrar com você para a Austrália. E a idade limite para isso é 23 anos de idade. Após isso, essa previsão não se aplica mais e seus filhos não podem mais imigrar como dependentes de você no seu visto de aplicação. Eu sou um profissional que estou imigrando para a Austrália e meus filhos só podem fazer isso, eu só posso incluí-los até os 23 anos de idade. Então, agora a gente vai passar para a última parte, antes de completar, quando está falando sobre questões como advogar na Austrália, como revalidar seu diploma, isso não vai dar para ser objeto da discussão de hoje, mas vamos perguntar um pouco sobre a questão dos refugiados, e principalmente a questão, estava falando para ele, de a gente ver na notícia cidadãos australianos não podendo voltar para a Austrália, cidadãos australianos com descendência asiática, né? Índia, Paquistão, não podendo voltar para a Austrália depois de visitar seus pais na época de Covid. Nós temos questão de refugiados australianos sendo mandados para campos de detenção e ilhas na costa australiana, e aí é isso que a gente vai terminar, antes de completar. E agradeço mais uma vez a Comissão de Direito e Relações Internacionais, OAB Santos, por toda a deferência e por terem me dado essa oportunidade com esses grandes profissionais de hoje. So, Mr. Duy San, could you, so regarding Australian policies during the COVID crisis, could you explain on how it applies to Australian nationals and citizens?
Yes.
And refugees, I think Australian nationals and refugees.
Yes. So currently Australia, because of the COVID-19 pandemic, they've got strict border restrictions in coming into Australia. So you can only travel to Australia if you're an Australian citizen, an Australian permanent resident, or a close family member of an Australian citizen or permanent resident. That means a child or a partner. The issue that was occurring in India was because of the massive spike that they were undertaking, and because the Australian government was concerned about the COVID-19 and the variant in India, they temporarily suspended travel for Australian citizens from India to Australia. But from my understanding, the flights from India to Australia has resumed, and Australian citizens have been able to come back to Australia. The issue now is that they've severely capped the number of flights coming into Australia for Australian citizens. So a lot of Australian citizens, from what I hear, they're unable to find flights coming back to Australia, and also the flights are at a ridiculous prices as well. In relation to refugees, it's not because of the COVID-19 policies they've introduced, but because in 2013, a lot of refugees or asylum seekers traveling by boat to come to Australia, a lot of them have died because of the dangers of traveling to Australia by boat. So the Australian government actually imposed a law where unlawful maritime arrivals are unable to obtain a visa in Australia whatsoever. So basically what that means is for boat arrivals, asylum seekers traveling by boat to Australia, even if they land onshore in Australia, they're unable to apply for any visa.
And so just short ramifications on that. Regarding, for instance, people from India who are coming back to Australia, nowadays you said that they can, but there is an issue of flights and all of that. But before, what would happen? They would be barred from entering Australia, or they would be put in quarantine, or sent back, even if they were Australian citizens. I think that's one question. And the other question is regarding this boat people. I don't know if that's the right expression to say, but the people that were arriving by boat, refugees by boat, they would arrive on Australian shore and they would be sent to Australian islands, and they would be sent back to their countries. Yes. With no possibility of their visas being processed. That's more or less the situation.
Yes, I'll answer your question about what occurred to Australian citizens traveling from India. So with Australia, when you arrive to Australia, regardless of whether you're an Australian citizen or a visa holder, you have to quarantine for 14 days, regardless of whether you're Australian citizen. It's a hotel quarantine that they've imposed. during that time when India was under their, I think, second wave, the Australian government basically cancelled all flights from India, and also cancelled flights from people who are trying to travel to other countries first and then travel to Australia. So, for example, some Australian citizens who were in India were trying to travel perhaps maybe to China or Singapore and then travel to Australia. However, there were fines imposed to those who were trying to circumvent those rules. Now, in relation to the unauthorized maritime arrivals, yes, from 2013, the Australian government introduced a law where if you traveled to Australia by boat and you did not have a visa and you attempted to apply for any visa, it doesn't have to be a protection visa, they were unable to. So what happens to those unlawful maritime arrivals were they were brought into detention with no options to apply for a visa, and a lot of them remain there in detention at the moment because they've refused to depart Australia or return home.
Is there a pressure for a change of the legislation? Has legislation changed to accept those people under humanitarian grounds?
Sorry, can you repeat that?
Were there pressure for a change of law? Was there a change of law? Can those people nowadays, I know that now we are on COVID, but if we weren't on COVID, could those people apply on humanitarian grounds or not yet?
No, unfortunately not. The reason why they introduced the law where unauthorized maritime arrivals were unable to apply for any visa whatsoever was because a lot of people were dying on their travels to Australia. So I think it was a big talking point in 2013, and it was a big election point as well. And there hasn't been any changes. It's straightforward. If you arrive as an unauthorized maritime arrival to Australia and you make it to Australia, absolutely, there's no way for you to apply for a visa in Australia, regardless of whether it's for humanitarian reasons, unable to.
Okay, so I'm just going to translate that and then we wrap it up for today, okay? Então, em relação à questão do COVID, da atual crise, né, sanitária global, da pandemia global, a Austrália é um dos países mais rigorosos com a questão sanitária. Visto por Austrália é uma ilha fechada, com algumas das espécies mais únicas do planeta, e toda vez que introduziram um animal estranho, como o coelho na Austrália, foi um caos, porque balanceou completamente a fauna. Então, eles são super rigorosos com isso, né? E atualmente, com a questão do COVID, só podem viajar para a Austrália ou cidadãos australianos, ou residentes permanentes na Austrália, ou filhos ou esposos de cidadãos australianos ou residentes permanentes. E o que aconteceu foi que houve uma certa, na mídia saiu, né, que muitos australianos de ascendência indiana, sejam indianos que mudaram para a Austrália e tiveram nacionalidade australiana, ou indianos nascidos na Austrália, australianos de ascendência indiana nascidos na Austrália, tinham voltado para a Índia, e houve a Índia, hoje em dia, o segundo maior foco de Covid no mundo, e não conseguiram voltar para a Austrália, né? E houve um certo escândalo em relação a isso. E o que ele estava explicando é que a Austrália não estava aceitando voos de pessoas vindos da Índia durante um tempo, né? Ou vindos da Índia por um outro país terceiro, por essa questão do pico que houve na Índia, principalmente na Índia, mas outros países asiáticos, mas principalmente na Índia. Mas que não houve uma proibição expressa da volta, que os voos estavam sendo cancelados e que agora essa situação já está se normalizando. Esse é o primeiro ponto. O segundo ponto é que houve também, ano passado, política rigorosa da imigração australiana, a questão de pessoas que vieram de barco, né, de bote, né, não barco transatlântico, bote legal, para a Austrália. E muitas pessoas morreram na viagem. Houve uma questão muito precária desses refugiados que vieram de barco, e houve uma lei em 2013 que proibiu a concessão de qualquer visto para pessoas que tivessem vindo de bote ilegalmente, né, para tentar coibir essa prática. Então, muitos chegaram na Austrália, não conseguiram nenhuma espécie de visto humanitário e foram encaminhados para campos de detenção em ilhas próximas da costa australiana para serem devolvidos para os seus países, mas muitos se recusaram e a situação continua ainda igual. Não houve uma mudança nessa lei, essas pessoas não podem pedir o refúgio na Austrália. Agora, na época de Covid, que a Austrália não está concedendo refúgio, mas é uma situação que dividiu bastante a sociedade australiana na época e é uma lei que ainda está em vigor para coibir essa prática dos refugiados que tinham vindo de barco, que estavam morrendo na vinda e essa situação ainda não se resolveu. Então é isso, agradeço a presença dos nossos 3 palestrantes. Vou encerrar por hoje, temos 1 hora mais ou menos de palestra e espero que tenha sido enriquecedor para todo mundo. Depois passarei meu e-mail, meu contato, qualquer dúvida, será um prazer pô-los em contato com os 3 palestrantes, Sr. Edward, Beshara, Andrew Flower e Duy San. So thank you very much to everyone, and I see you guys next time. Thank you very much, and wish you well. Bye-bye.
Thank you.
Yeah.